Welcome everybody to this edition of the IMI and SIMI Singapore Convention Mediation Series. We have a fantastic guest today who will be introduced shortly. But first, just some light housekeeping. For those who haven't used a webinar on Zoom before, you'll see there's a Q&A button at the bottom of your screens or on your phones. We encourage you to submit questions throughout the presentation and afterwards as well, and that way our lovely presenter will be able to get to them in due course. But I'll now invite Marcus Lim, who's the CEO of the Singapore International Mediation Institute, to welcome our guest.
Thanks, Laura. Welcome, Shanti, to this evening and joining us for the latest edition of the Singapore Convention Seminar Series. So for our guests tuning in today, those of you who are based in Singapore in Asia, Shanti should be no stranger to you. She's actually based in Malaysia, and but she's had roots in Singapore, right? With degree in law, LLB taken at NUS. And so you actually see Shanti quite often and many of the events, not just in Singapore, but overseas as well. It's always great to see a friendly face, and I often run into her wherever we do international panels or conferences. And Shanti's one of those rare people who can really light up the room the moment you see her. And so she's got an amazing personality. I've always enjoyed speaking with Shanti, and I'm so glad that she could join us today to speak on, being that we are SIMI, a topic that will be very close to our heart. How is Malaysia taking to the SCM? But for further details and Shanti's background professionally, I'll let her walk you through her illustrious career, and also to talk to you and talk to us, share with us more about the SCM and Malaysia. So Shanti, over to you.
Thank you so much, Marcus. That's a very kind introduction. Thank you to Marcus and Laura, as well as Jessica, SIMI and IMI. But this is a real privilege to be invited to share my thoughts on the potential of the Singapore Convention in Malaysia. Now, give me a moment. I'm going to share my screen. So a very good morning, afternoon and evening to all of you who are tuning in from all over the world. It's a real privilege to be able to speak to you and share something that's very passionate to me, and that is all the elements of what mediation is all about. A little bit of a background about me. Yes, I'm from Singapore. I've been in practice for over 25 years. Now I run my practice in Kuala Lumpur. I'm an arbitrator, an adjudicator, as well as a mediator. And of all these three hats, or rather the four hats, as a litigator as well, I am most passionate about mediation. And with what has been happening around us with COVID, we're starting to see that mediation may also need to move online. And there's so many things that we need to develop about mediation. And I really look forward to good questions from everyone. On that note, this is an overview of the next 15 minutes. I'll give you a little bit of a history about mediation in Malaysia, what's happening now, and the vision of the future of mediation in Malaysia. Now, the snapshot of mediation in Malaysia is this. We have a statute, a Mediation Act, 2012. We are also a very proud signatory of the Singapore Convention on Mediation. We were standing shoulder to shoulder with all our friends from Singapore at the signing ceremony last year with 45 other countries. Mediation is available in Malaysia even now at ad hoc basis and through various institutions. The oldest institution is the Malaysian Mediation Center. The Asian AIAC is another mediation. They also have a mediation component. And there's also the Securities Industry Dispute Resolution Center, one of our more successful mediation centers. So a little bit of a history from a Malaysian perspective. Malaysia started its mediation journey at the same time as Singapore in 1999. Unfortunately, we had low funding, no legislative and regulatory framework. In those days, mediators were expected to work for free or sadly unsustainable fees. And mediation was put into a charitable frame, a social service as such. And in fact, it was not uncommon to hear people wanting to do mediation when they retire, so that they could give back. So it was a struggle for mediation to be taken seriously. And even though there were many mediators trained in those years, the naughty years, the 2000 to 2010, even the mediators had a hard time convincing their own partners to offer cases for mediation because the value proposition was very low. In 2010, our mediation, our courts introduced mediation to reduce backlog. Mediation in the courts is not quite what we may be used to in our trainings. And what would happen is that lawyers were often excluded from the mediation chambers, and the judges or the registrars would undertake the mediation in the absence of lawyers. And unfortunately, clients also treated it as the charitable arm of lawyering. So with that, mediation got the just mediation narrative. And for some people, it may be surprised to know that it was not unusual for lawyers to expect lawyers to decimate their fees or even waive their fees for services rendered during mediation, because it was just mediation. In fact, clients went to the extent of saying if it was mediation, the lawyer should do it for free because it's value add. So with all this as the background, you can imagine, it's not rocket science, the business model to promote mediation as a key dispute resolution tool was very difficult to develop. And so what was the consequence of the poor positioning? Obviously, it impeded the growth of mediation in Malaysia. Very few firms expressly encourage mediate first policies or mediation encouraged policies, or the ultimate unicorn, good case, let's mediate. Firms just could not afford to develop the viable business model that was necessary because of the just mediate climate. Having said that, the believers pressed on and the Mediation Act was enacted. Unfortunately, it did not have enforcement provisions, but that's going to change after we amend our Mediation Act. So that was dead. Now we are in a different time and space. It was a surprise to many people when the Singapore Convention on Mediation was rolled out, which highlighted the utility of mediation as a mechanism for dispute resolution. It suddenly opened up the option for parties who wanted swift international commercial solutions with enforcement measures. And it created heightened duties for mediators, thereby improving the profile of mediators as well. So Malaysia has taken on the task to get ready for the Singapore Convention. What is wonderful is that because of the high signature event of the signing ceremony and Malaysia's participation in it, the prominence of the Singapore Convention on Mediation has inspired new conversations. There are a lot of people who now want to train as mediators, but as all of us know, it's not just about training, it's about practicing and being able to use the craft in an effective way. So in our mediation community, we are recognizing that standards for mediators have to be established. And soon, we will see that professional mediators will need to be distinguished from social mediators. Already, industries are calling out for specialist mediators who are both trained in mediation as well as having subject experience. And as far as the legal profession is concerned, the Malaysian Mediation Centre has undertaken efforts to educate lawyers on how to value their mediation services. The just mediation narrative should not prevail when they are presenting mediation as an option to their clients. The reality is that if lawyers are not given a respected seat at the table, lawyers will naturally choose forums where they're given a voice and a respected consideration. And this is something we've recognized from many years ago. So these conversations have been ongoing to lawyers in mediation advocacy talks. At the same time, because we recognize it is an ecosystem where the lawyers are the gatekeepers of disputes, the mediators must be able to deal with the lawyers in a respectful way, to accommodate them, and to utilize their valuable skills so that the parties are able to explore the solutions that they can live with. It's not unusual for us when we have lawyers in the mediation chamber to see the dynamics between parties and the decision makers and the lawyers, where that relationship actually helps to nudge the party towards making a decision that they can live with. The lawyers remain a very important part of the equation, and will continue to do so. So now, Now in the last few years, we are seeing more firms strategically proposing mediation and more clients know to ask for mediation. The numbers are not great yet, but we are seeing corporate lawyers include mediation in multi-tier dispute resolution clauses. This gives the foot for the litigators to use as a first step to help their clients consider mediation to solve problems that may arise. And now, in this current economic climate, where people are speaking about business survival, economic survival, corporate and dispute lawyers are going to need to advise clients on the benefits of swift, cost-effective problem-solving measures, because cash is going to be a real issue going forward. From now, we move on to the next. What is going to happen in the future in Malaysia? So as I shared earlier, being a signatory to the Singapore Convention on Mediation, Malaysia, we already have the working groups to amend our Mediation Act and to ratify the convention. We were all hard at work. I'm part of the committee, I'd like to share. We were all hard at work doing this until the COVID crisis. So it's only a matter of time that the amendments to the Act and the rules will be done. But in the meantime, we are still trying to encourage parties to consider mediation, because for those of us who are in this area, we know that a well-mediated matter generally has high compliance rates. In that vein, just these last few weeks here in Malaysia, we've been talking about a national COVID-19 mediation initiative being formulated, so look out for some announcements hopefully in the next few weeks. As part of the now to next, in Malaysia we realized that we also need to spend some effort to upskill the professional mediators so that they're ready for international commercial mediation. There are going to be expected codes of conduct to be met. And now there is also the online mediation experience that I think many of us are going to have to upskill ourselves in order to develop going forward. Apart from that, standards need to be set for mediators. We're lucky that we have examples to follow in SIMI and IMI. These are the kind of standards that we want to be able to establish as well. We actually do have mediators who can meet these standards, and it will be important as the convention is used by parties that they have confidence in the mediators that are available. In order to boost mediation in Malaysia, we're hopeful that some rules will come in for cost sanctions, tax incentives, and even rules of etiquette, which I think Singapore has one where lawyers are obliged to share the full buffet of options to clients. And those sort of etiquette rules are not quite yet in the Malaysian domain, but I foresee happening soon. And from the corporate sector, I think Hong Kong has had mediate first policy initiatives, and I foresee that in Malaysia too, we will have mediate first initiatives, mediation encouraged initiatives, and if lawyers are brave, a good case, let's mediate initiatives as well. So on that note, all of us are looking at new normals ahead. All our notions of normal are being tested. So as advisors, as lawyers, as professionals who are going to be guiding parties to overcome the many problems that will be surfacing after the MCO, the question to ask is this: what is in the best interest of clients for effective solutions? Do the clients have time and money for litigation and arbitration? And even if they do, does the counterparty have resources? Will there be an effective outcome at the end of the day? And if there is a question mark to that, would the parties consider mediation or mediation first? And on that note, I look forward to the questions you have, and thank you all, and stay safe.
Thank you so much, Shanti. That was really interesting, as well as I think timely and relevant. So we have one question so far, and I do encourage others to submit their questions if they would like to.
Right.
Can you see the question there now?
Yes.
Okay.
So the question is there enough mediation cases in Malaysia to make it viable for lawyers in Malaysia? Now, I'm going to answer it in this way. If you're asking from a perspective as a mediator, you cannot be a pure mediator and have a business model that works every day. It just won't work. So even for me, I am a staunch supporter and an advocate for mediation, but I have a mixed practice, and that is just the reality of it. But when we talk about disputes as lawyers, strictly speaking, every case that can fit a mediation model. The challenge that lawyers tend to have is worrying about whether the other side will be open to mediation. And that is a conversation that lawyers may need to have with their counterparties. Sometimes when you have a party that's still on talking terms with their counterparty, even though a dispute is brewing, the proposal of having a mediation may be helpful to steer the matter towards mediation. Now, just to share, because I think this is Laura, this is actually something that really bothers lawyers. They don't know how to position the business model in order to encourage a matter to go for mediation. And I'll share something that we do share with the other lawyers. There are different models to have arrangements with clients. Sometimes you can go on an agreed fee basis, whether you resolve the matter through mediation, arbitration, or whatever, litigation, the parties have an understanding of what the value of a solution is. Other times you can have an agreed figure based on how much work is done getting out. Oftentimes, and this is something I've experienced in the past, when you do getting up, it's a lot of work, and clients must value that. And that work is important to lay the foundation before you can go into mediation. So that's where the value proposition needs to be articulated to the client so that they understand that what they're getting is value for the time and money that they're paying. So one question here, there is a need to build the ecosystem to support mediation. In this regard, there needs to be more institutional frameworks for industries that need the support, where there is a significant disparity with regards to the leveling field. Okay, so I'm just going to take this question in sections, all right? In relation to the suggestion that there needs to be an ecosystem to support mediation, absolutely. Now, as I shared earlier, we started, when I say we Malaysia, we started the mediation journey in 1999. The Malaysian Mediation Center is part of the Bar Council. It's a separate entity, but it's part of the Bar Council. It is not like SMC, which is a standalone with executive directors and executives. That structure does not currently exist in Malaysia as far as the Malaysian Mediation Center is concerned. It is something that probably needs to be looked at. Right now, we are all volunteers, and there are 2 staff that support it, but we're still been going strong for all these years. As more and more cases come in, I do see that more institutional support is going to be necessary. And let me just get back to your question. Online platforms to facilitate effective mediation. Okay, I'm trying to find the question. Okay, what steps can be taken to bring all stakeholders to the table for an effective plan going forward? All right, so I think that's the main question. Right now, just to share with you all, the Ministry of Law has pulled together a pool of people who have been doing mediations in their own silos. So all of us have come in, and we're part of the working committee, part of the working group, to come up with amendments to the Mediation Act and to propose best practices going forward. And you're quite right, with online mediation, which most of us weren't actually thinking about even 6 months ago. Today, the reality of online mediation is something that we're going to have to pull up our bootstraps and get organized. So, I mean, I have obtained my own online mediation platform. there are going to be concerns about confidentiality, whether someone's sitting at the back recording. These are issues that we are currently looking at. And so I won't be able to give you the answer immediately, but certainly keep looking at the space. Mediators around the world, we are all grappling with the same questions. And I think with our collective discussions, we'll be able to come up with the best practices going forward. Right. One question is an excellent question. How does one mediator in Malaysia gain experience or the pilot flying hours? All right. So you would have recollected that one of the things that we've identified is because standards are going to be very important. Part of establishing standards is also establishing a system where newly trained mediators can get their pilot flying hours. Right? So just to share, I got my pilot flying hours by flying to Singapore regularly to mediate for free at the subordinate courts, because that was the system that Singapore already had more than 10 years ago. It was a very expensive way to get my pilot flying hours. I hope to make it more painless and propose better options here in Malaysia. So there are going to be ideas, and I'm happy to hear some ideas from the industry as well. How do we protect confidentiality of documents used in online mediation? That's a very good question. And right now, this is a question that we are all actually mulling over. In addition to protecting online documentation, the confidentiality of online documentation, we're also talking about protecting the confidentiality of the whole online mediation process. It's all well and good that you can see me in this little landscape, but you have absolutely no idea if someone else is here with me in the room, and this is going to be a challenge going forward. Now, in terms of documents being shared during a mediation, what we do in our warm body mediation experience is that in my firm, when we run mediations, we actually put a top on it saying for mediation only. That works in our mediation in the warm body. I'm wondering whether this might work in the online scene with a document which has been cut across with the word for mediation only. In Malaysia, mediation is protected by statute. So I'm fairly confident that there are some good arguments to support that, but I think this will be something that needs to be discussed as we go forward. Going forward, how do you see technology changing the mediation landscape, especially with COVID-19 forcing a shift of many processes online? Keith, this is an excellent question. In fact, on Friday, I had a mediation schedule. And when the movement control order was announced, I had proposed to the parties, would they consider doing online mediation? And to get them comfortable, we had a council meeting on the online platform. And this was just to road test, see how everyone was comfortable with it. Confidentiality was one of the concerns. The other one was the technological interface by one of the parties with talking into a computer. So the conclusion at that council discussion was that we would hopefully wait for the MCO to lift, because there was one party who wanted that warm body experience in a mediation. So this is where flexibility is going to have to come in. I actually see that at some point, parties will agree on the parameters for online mediation. Otherwise, we are going to be constantly waiting for a time where social distancing measures have been relaxed before we can do effective dispute resolution and help parties. Can a certified mediator mediate cases in Malaysia without the umbrella of a designated service provider to have an enforceable settlement? So the answer to that question is this. At this moment, the Singapore Convention has not yet been ratified. So these concepts don't actually, the designated party institution has not yet been put in statute yet. Conceptually, our mediations will be open to the international market as well, because this will be something that would have to be part and parcel of international commercial mediation experience. So the answer right now is that there is no regulation yet. Do appointed mediators need to be able to communicate in Bahasa Malaysia? Short answer is no. You can it's what the parties are comfortable in. In fact, the maximum number of languages I've had in a mediation is 4. We had a translator, someone speaking in Cantonese, English, and Bahasa Malaysia. Sorry, and they spoke to each other in Hokkien at some point as well. So the idea is that the mediator must be able to understand what the party wants to say. If the parties are comfortable in Malay, then a translator is used if they've chosen you to be a mediator and you don't speak any Malay. Do fees charged by the Malaysian Mediation Centre and other centres encourage lawyers to come forward to be trained and accredited? So I'm not sure what that question is pointing to. Because we have a Competition Act, it's really up to the mediator to propose the fees that he or she wants to suggest. I don't know whether it will encourage lawyers to come forward and be accredited. Just like arbitration and arbitration counsel, it depends on what the parties are comfortable paying as well as charging. So whether lawyers are prepared to work for mediator fees or mediator counsel fees will be really up to the parties themselves. I hope they're encouraged to at least try and get training in mediation at the very least. Are there any recommendations for countries to implement the convention? This is from someone in the Ukraine. Let me just answer that by saying I'm a believer in this process. So I'm looking and I'm trying very hard to find how in Malaysia can advance its mediation landscape. And this is unique to our experience here. You would have to make an assessment of whether the hearts and minds of the people in your country are open to mediation as a concept. Bearing in mind that Malaysia and Singapore started our mediation journeys at the same time, we had 10 years where mediation was really considered a charitable thing that people did to be kind. It's only now that people are recognizing that one can professionalize in this and swift solutions can be presented to clients potentially through mediation processes. Right, so this is my good friend Bill. I'm going to read your question. Do you agree the COVID crisis may accelerate the use of mediation worldwide as bodies realize the benefits of remote working and low-cost solutions? Bill, I completely agree. I think it's something that parties and lawyers and advisors have to come to grips with. We are in such unusual times, and because we're hearing the echo of business survival, economic crisis, I think this would be the time that parties will consider effective problem-solving measures. And we call it mediation, and that presents a process that people can use immediately. A party who approaches an advisor on Monday could actually easily arrange a mediation on Friday or even a few days, as long as the counterparty also sees the value in finding a swift solution. How do you think the convention will impact on the attraction of the Med-Arb approach? All right, so arbitration has done tremendous things in the last decades. And in fact, when Med-Arb came up as a solution, there was a little bit of pushback because the interfacing was not very clear. And what Med-Arb is where a party starts a matter through mediation. If there are issues that need an adjudicated decision, then the parties would refer those issues to arbitration. Now, in my experience, the mediator and the arbitrator are two distinct parties. There is conversation about double hatting, and although there are two schools of thought, some people feel that double hatting is not appropriate because the mediator and the arbitrator should maintain separate hats. I know that there's another school of thought that says, well, if the parties have already developed some trust element with the mediator and they waive any objection to the mediator sitting as arbitrator, then parties can continue and achieve a Med-Arb solution. I have not personally been involved in double hatting, I usually do the mediation component, and if there is an issue that needs an adjudication or an arbitration, only that issue goes out for a determination. Would a mediator be considered a profession whereby a mediator could commence his own business? The answer is at some point, I think that is going to happen. It already is happening in other countries. I know mediators in Australia, in Singapore, and in the US who have been just purely professionally mediating for many years and doing it very well. In order to do it in Malaysia, though, I think there would need to be some rules as well as some regulations, bearing in mind that potentially after the convention applies to Malaysia, a mediated settlement agreement can be set aside for mediator misconduct. So these are some of the considerations that we have to take into account when we are doing our rules and amendments. Given the rise of debt defaults, do you expect to see an uptick in commercial mediation in Southeast Asian region? All right. I'm just going to, and what are the state organs, if anything, to facilitate or encourage mediation in place of aggressive enforcement or acceleration of loans? Now, this is really an excellent point. We already know that insolvency mediation is something in Singapore. It has been, I was part of the teaching faculty, teaching the restructuring and restructuring lawyers as well as the accountants about the concepts of insolvency mediation. We've actually already had conversations here that insolvency mediation might be one of the mediations that we're going to see happening here in Malaysia. Whether we have the right mediators to help push this along is something that's being discussed literally as we speak in these next few weeks. Now, whether the organs of government are aware enough about this to help support it, this is actually one of the considerations going forward. If parties can resolve the matter swiftly, where what incentives might be given to them, this is something that's being discussed in the National COVID-19 Mediation Initiative that is being formulated right now. So I can't give you an answer to that right now, but believe you me, we're already thinking about it and trying to find a way that would make sense to all the professionals who need guidance on this. Do you think a body such as AIAC is needed to support optimizing and promoting efforts to build mediation in Malaysia? AIAC has its part and its role to play in promoting mediation in Malaysia. A lot of the Malaysian Mediation Center mediators are also on the AIAC panel. We're a very small community in that sense. What I do think, and this is my view going forward, we may need to have an independent mediation center where it is someone's paid job to promote mediation and promote Malaysia as a mediation center. We can see how it's being done in Singapore. It needs to be less of a voluntary thing where we spend our time and do it for the good of the nation, and perhaps that's what is needed. A bespoke for mediation center. But that's just my vision. Do Malaysian courts direct parties towards mediation, and how often is this done? Now, in general, our courts are supportive of mediation, but that's court mediation. So the parties have gotten into an adversarial frame, and then they go to court where they are asked to go for court mediation. Now, there are wonderful judge mediators who are mediators in their own right, and they mediate wonderfully. Unfortunately, not everyone mediates in the same manner. And one of the feedback that we get from lawyers is that they're not included in the mediation discussion. The lawyers are spoken to by the mediating judge or the registrar and then asked to leave, and then the parties come in for private sessions. And that creates a little bit of a disconnect. And I know of lawyers who tell me that before their parties go in, they tell them, don't agree on anything, just say everything I need to check with my lawyer. So our knee-jerk reaction may be to get upset by a statement like that, those of us who are mediators, we recognize that that is someone wanting to be relevant to the process that he has or she has assisted the client to bring to court. So I think the respect component needs to be improved so that lawyers feel part of the process. Unfortunately, in the early days, lawyers were considered obstructive, and they were not handled as well as they probably should have. What, in your view, is the minimum time period required to conduct a mediation? I asked this I was given 15 minutes to mediate a case which I manage with cooperative parties now. That is extraordinary. I can tell you I've never mediated anything in 15 minutes. I think my shortest record is 45 minutes. And that was because while the parties were waiting to come in, they reached an agreement. And when the parties finally came in to have a chat, one of our roles as mediators is to check the durability of what has been agreed. And so that took a little bit of time, and they drew up the agreement. So my record is 45 minutes. If you've done it in 15, well done. I don't think there is a minimum time, and nor should mediators put that sort of pressure on themselves, that there is a ticking time bomb to help the parties resolve. Right. So are you able to share your experience in an international mediation setting? We'll do that very quickly. Yeah. So there are different types of international mediation settings. One was where the party was sitting in another country and was beamed through online. The issues were the same because usually in international mediations, there are a few things that you have to go into the mediation bearing in mind. Culture is one aspect, and language is another aspect. Understanding on how people speak, and perceptions of aggression are different in different cultures. So you're there to balance off what may be perceived to be aggressive, but actually it's just a cultural, the cultural expression of that particular party. Now, so even though I did an international mediation, the parties were all Asian, and all from Malaysia actually. So we didn't have that cultural problem. We really just looked at the problem, and the international context of that mediation was just by virtue of the fact that everyone was in a different country. So there were no unusual cultural matters to overcome in that particular international mediation. Another one where, again, even though the person was not from this part of the world, because the issues, again, were something that were commercial in nature, we just accepted how people interact with each other. We took it a bit slower because there were some language challenges, but as long as we brought the pace of the mediation down so that people could follow. And there were a lot of private sessions where I made sure that the parties understood what was going on. So this is where the mediator has to really think through the process before they embark on what I consider complex mediations. And the complexity is because the person is either online or from a different culture or a different language background. And this applies to any mediation, not just in international mediations. Even in a plural society like Malaysia, you have the multiple elements that you need to think through beforehand. You can't just turn up at the mediation and expect to be able to navigate the parties. There is preparation, not only for the advisors and the parties, but also for the mediator to anticipate what challenges may turn up and how you plan to deal with those challenges. Are there any other questions, Laura?
I have one. Yes. Actually. So just to wrap up, I would really like to know, what are your hopes for mediation in Malaysia, say over the next 10 years? What will it look like 10 years from now?
10 years from now, that's a fabulous question. I was just trying to think what it'll look like next year, but okay.
10 years. Let's aim big, yeah.
I think in 10 years' time, mediation will be part of our natural language. Mm-hmm. And the boards of directors, because it starts with the parties, right? Today, boards of directors may be inclined to want to resolve problems through litigation because it demonstrates strength and it demonstrates determination to get justice. In 10 years' time, I think boards of directors might be very different. They might hold their general counsel more to account to say, why wasn't this mediated first? Because a solution, if it could have been found, would have saved time, money, and the general counsel could spend more time in business development opportunities. So that's what I foresee in 10 years' time. I think lawyers will be more comfortable in the mediation chamber. You see, a lot of the younger lawyers have been already schooled in the art, in the framework of a mediation. So when you say mediation, there is no big pushback. And I am sensitive to the lawyers of my generation and earlier. When I was in law school, we were never taught about mediation. We were taught negotiation and arbitration. And for mediation to come in, I think to be fair to my peers, we need to be given time, and I think lawyers need to be given time to find their footing, to be able to articulate the value proposition for what is a very valuable service that they're going to be giving to their clients. In the early days, and I was trained by some mediators who said, leave the lawyers out of the room. And as a lawyer, I could feel the visceral reaction to not being included once I had brought the party and primed the party to consider mediation. So these are the things that we have to heal. It can be done. Heal, move forward, and develop a business model that is sustainable. We need to be fair to everyone in the ecosystem.
Perfect. I think it's definitely a worthy vision as well as an attainable one. So Shanti, thank you so much for joining us today and sharing your knowledge and your insights into the Singapore Convention, but also the context of mediation in Malaysia more generally. I know that I have learned a lot, and I hope that our attendees have appreciated it as well. Thank you to everyone who came for your fantastic questions as well. And I hope that
Thank you so much. Very good questions.
Yes, thanks, Shanti. We're still getting new questions, actually.
Yes, I'm just noticing that. Would you like me to answer that?
I think just one, which is actually a very simple one.
Yes, I think that's an important question to sort of clarify.
Accredited mediator,
yes.
Yeah.
Can an accredited mediator by MMC be registered as an arbitrator by AIC? And the answer is no, because they're two different processes. So if you're a mediator, you can apply to the AIC to be on their mediator panel. But for arbitration, there is a different pathway to become an arbitrator. All right, I hope I've answered that question.
Yep, I think that more than answers it. Yep. All right,
thank you all for having me. It's been a real pleasure.
Likewise, thank you, Shanti. Very happy to have you with us tonight. Thanks, Laura, as always, for coordinating
Thank you, Laura.
everything. Thank you all for joining us, and that's it for tonight. Thank you.
Thank you. Good night.
Bye, everyone.
Bye-bye.
Bye, everyone.